Hello everyone and welcome to our anti-money laundering webinar on client and matter risk assessments. We want this session to be as interactive as possible, so if you have any questions, please submit them using the question link below this video. You can submit them with your name or anonymously, and we'll try our best to get through all of the questions throughout this webinar. A recording of the webinar and the slides will be available on our resources page after the event, so please feel free to share that with your colleagues. I'm here today with regulatory managers Declan Brown and Michelle Clement, and I'll hand you over to them now.
Hi everyone and welcome to today's webinar on client and matter risk assessments. My name is Declan Brown and I am an anti-money laundering regulatory manager within the AML proactive supervision team here at the SRA. As part of my role, I carry out on-site AML inspections at firms. The purpose of these inspections are to assess firms' compliance with the money laundering regulations. Where we identify good practice, we take this away and we share it with the industry. And where we identify any weaker areas, we try to work with firms to help improve compliance. Our team are also responsible for carrying out and leading on AML thematic reviews.
Good afternoon, everybody. My name is Michelle Clement, and I'm also an anti-money laundering regulatory manager, and I have the same responsibilities that Declan's just outlined. I led on the client and matter risk assessment thematic review we conducted over the spring and summer of 2023, which forms the basis of some of the information we will be discussing shortly.
Thanks, Michelle. So in today's webinar, we're going to talk to you a bit about our findings from our most recent thematic on clients and matter risk assessments. We plan to share with you some useful tips on what you can do when completing your own clients and matter risk assessments, as well as common areas of non-compliance that we see when reviewing risk assessments on files. We're also going to illustrate how you may use the clients and matter risk assessment template that we developed off the back of the thematic, and there'll also be an opportunity for us to answer any questions that you may have on client and matter risk assessments.
Thanks, Declan. So I'll be starting by sharing the importance of completing a client matter risk assessment. Probably goes without saying, but a client risk assessment, should identify and assess the risk posed by a specific client. And a matter risk assessment should focus on the specific risk factors that a matter presents beyond or different to the client risks already identified. It's important to properly risk assess your clients and matters because failure to do so can expose your firm to the risk of abuse by criminals. So aside from the fact that it's a mandatory requirement under Regulation 12 and 13 of the money laundering regulations, which came into force in June 2017, there are lots of benefits for carrying out risk assessments. So firstly, conducting a risk assessment will help you to identify and understand the money laundering and terrorist financing risks that your client or a matter exposes your firm to. And this in turn will help you to decide whether you wish to accept the client. It will help you to understand if the work or the client or the work involved is outside of the scope of your firm's risk appetite, which of course should be documented in your Regulation 18 firm-wide risk assessment. If you choose to accept the instructions from the client, a client matter risk assessment will help you to determine what level of customer due diligence you need to undertake, and if there are any additional steps you need to take to mitigate the risk that's posed. Keeping a written record of client and matter risk assessments will help you to comply with your ongoing monitoring obligations. This means that you would be more likely to spot any changes to your client's circumstances or any changes during a transaction if you have a written risk assessment to look back on. So if you consider the client to be low risk, for example, and new information comes to light, then that might lead you to consider that actually they are now higher risk. And it will be helpful to fee earners or anyone else who's working on a file if there's an audit trail of the decisions that have been made on that file. Another benefit of risk assessing clients and matters properly is that good compliance can also promote good business. So for example, if you have a good understanding of your client's business structure, you may spot opportunities to refer work to other departments, or if you notice that a client is coming up to retirement age, for example, from their date of birth, you could use that opportunity to refer them for private client work, such as getting a will drafted. Another benefit of properly risk assessing your clients and matters is your firm's reputation. So if criminals are aware that you ask questions, they may be put off from using your firm. It would be easier to use a firm that does not ask too many questions. And lastly, a risk assessment can also be a useful tool to understand your firm's exposure to financial sanctions risks if you choose to use it that way. So now we're moving on to the thematic review and our findings from this review. So the review involved us looking at the processes that 30 firms use to risk assess their clients and matters. And we found that in 94% of the firms that we went to, they had a process in place to risk assess clients and matters. However, when we delved in deeper, it became clear that these processes were not always followed by fee earners, which then leaves the firm open to abuse by criminals. In nearly half of the files that we reviewed, we noted that they did not contain a client matter risk assessment. On a minority of files, I should say, this was because the files we looked at were in the early stages of the transaction, and it was reasonable for a risk assessment not to have been completed on those at that time. However, that was in about 6% of cases. We observed some good and poor practices, which we will be mentioning shortly. And ultimately, as you might be aware, there were 3 outcomes from the thematic review, which we published on our website in October 2023. So the first outcome was a warning notice, and we published this warning notice because of the high levels of non-compliance that we're seeing from our proactive work in this area, namely our desk-based reviews and our inspections. The second outcome was the publication of the thematic report, and the report set out our findings, which also includes a good and poor practice guide, which Declan and I will provide some examples of in a moment. And the third outcome from the review was the creation and publication of a client and matter risk assessment template. And we created a template because we recognized that client matter risk assessment template can be an effective tool to risk assess your clients and matters if it's used properly. So just to be clear, we do not expect firms to use our template, but if you do choose to use the template, we would really encourage you to make sure you adapt it to capture the risks that your firm is exposed to through your clients and the type of work that you do. We've also published some guidance on how to use a template. And now over to Declan to discuss some of the poor practices that we observed.
Thanks, Michelle. So up here, we've included some examples of what a client and a matter risk assessment isn't. And the first example that we have up there is an e-verification system rating. Now, quite often, firms will confuse carrying out an e-verification search with carrying out a client and matter risk assessment. And quite often, firms will assume the e-verification search has carried out the client and matter risk assessment on their behalf. Now, the information these searches collate is certainly useful to your overall assessment of client and matter risk. However, they fail to provide any real assessment of the information which has been gathered and how it applies in the context of your client or your matter, which means that it would likely not comply with regulations 2812 and regulations 2813. Ultimately, your client and matter risk assessment isn't something which can be outsourced to a third-party provider. The second point that we have up there is something else that we've seen when we're looking at risk assessments on files. And this can only be described as where files contain a business risk assessment. So these risk assessments will look at whether the client has the ability to pay their fees or making sure the fee earner in question has the relevant expertise to handle the matter. Now, while there's no harm in considering wider risks, the purpose of your client and matter risk assessment is to, 1, evidence that you've considered the money laundering risks, and 2, to inform your approach as to the level of client due diligence that you should be gathering to mitigate the money laundering and terrorist financing risks. And the last point that we have up here is something else that we've come across when looking at risk assessments, and this is where firms are treating client and matter risk assessments as a red tape exercise. So again, we have in the past come across examples of where firms have carried out client and matter risk assessments after they've received funds into their client account as part of a transaction, or after our request to view the file. Now, your client and matter risk assessments are an important document to help evidence that you have considered the money laundering risks and taken the appropriate steps to mitigate them. It's important that these documents are shared with anyone else who's working with the client or on the matter, so they're aware of the risks that they need to look out for and the steps that they need to take. Ultimately, if you're unaware of the risks, you cannot take the appropriate steps to mitigate them. We have and will continue to take action against firms who fail to carry out client and matter risk assessments. Now over to Michelle to talk you through some good practice.
Thanks, Declan. Okay, so we did observe some good practice as well, and I've selected 3 to share with you today. So the first is in relation to recording rationale. So where risk ratings were used, some firms recorded how they arrived at that rating and the thinking behind it. So an example that pops to mind is one of the files we reviewed. A matter appeared to be high risk on the face of it, but was marked as low risk. And when we reviewed the risk assessment, the fee earner had actually recorded their rationale, and it was clear how the firm had arrived at the conclusion that they did. The second is in relation to using tailored templates. So we saw instances where firms had tailored their client and matter risk assessment template to capture risks that they considered were specific to their firm's client base. So the firm that comes to mind had a particular group of clients that they've identified as posing a higher risk of money laundering to their firm in their firm-wide risk assessment. And consequently, they added 1 or 2 questions to their client matter risk assessment template, which would help fee earners identify if a prospective client fell into the category of clients they felt posed a higher risk to their firm. And then the last is in relation to reviewing your risk assessment, at appropriate times. So we noted that firms were reviewing their client matter risk assessment at key stages in transactions. So for example, on a couple of files, we could see that fee earners had reviewed the initial risk assessment prior to exchange and completion in the conveyancing matter. They also provided details of further checks that they had conducted between the last review and the current review, which we considered to be good practice. So over to you, Declan.
Thanks, Michelle. So now some practical tips on what you can do when completing client and matter risk assessments. Now in this example, we'll be using our template to demonstrate how you can effectively assess client and matter risk. Now the template is available on our website alongside an example with a guidance document. Now, the scenarios in our examples have been created as an aid, and they should not be used as an endorsement of a specific rating for a specific type of client or a specific type of matter. Each client and each matter should be assessed based on its own individual circumstance. Now, as Michelle mentioned earlier, if you do choose to use our template, we'd encourage you to adapt this so it suits your firm. We've seen some really good examples from firms where they've incorporated elements from our template into their current risk assessment process. You'll be pleased to hear that we won't be going through each of the questions individually. We'll just be focusing on some of the key areas that we often provide feedback to firms on.
Thanks, Declan. So we're going to be looking at section 1, which of course is looking at the type of clients that you're dealing with. So whether it's an individual or if it's an entity. And the answer to this will of course determine the type of information you need to collate about the client. So as you'll be aware, the information required for individuals are different to the information that must be collected for entities. So it's important to be clear from the start who your client is. So it might sound like an obvious thing, but we have seen matters where the firm has been instructed by an individual on behalf of a company, but due diligence is completed on the individual and not the company who is actually the client. At the start of your risk assessment, it's also important to consider whether you are dealing with a new client or an existing client. So again, for new clients, you should really be considering if the new client would expose the firm to new risks and how those risks will be managed. I'd like to also emphasize that you should not assume that existing clients are necessarily lower risk. I mean, the benefit of dealing with a repeat client is that you may have due diligence from previous engagements with the client to inform your risk assessment. So the start of the matter would be a good time for you to know information on the client's occupation, if you're dealing with an individual, the source of the client's income and or their source of wealth. And that may be whether that's the client's job, if you're dealing with an individual, or perhaps the type of business a company might be involved in if it's a corporate client. And this is because this would be a good reference point as the matter progresses. So this may assist you in determining if the information the client provides to you later makes sense for what that client and their financial circumstance is. Over to you, Declan.
Thanks, Michelle. So section 2 of the template focuses on any initial risks that you may have identified. And this is split into three different subsections: client risk, delivery channel risk, and jurisdiction risk. Now, as you can see, the template contains various prompts that you should consider and provide an initial assessment of. And each subsection contains a three-format text box where you can record any issues and outline what steps you plan to take to mitigate them. There's also a separate section for entities where you can record details around beneficial owners and directors, alongside the steps taken, for example, obtaining copies of their passports and utility bills to verify their identity. Now, the idea of this section is for you to consider the initial risks during the very early stages of the client relationship. So, for example, following a conversation with the client where they've made it clear that they will instruct the firm. The prompts are there to help you consider whether there are any initial risks that you need to look out for or initial risks connected to the client. So, for example, in the scenario that we've provided, the client is based in Birmingham and our firm are based in Bristol. Now, in ordinary circumstances, it may be considered a red flag to not be instructed by a client who's based within the local area. However, in this example, we've recorded our rationale around why we feel it's not a risk. And also under the delivery channel risk, we've recorded the measures we plan to take to verify, to mitigate the risk of not meeting the client face to face, and the measures that we plan to take to verify their identity.
Thanks, Declan. So now moving on to section 3 of the template, which focuses on assessing matter risks. So as I mentioned earlier, a matter risk assessment should focus on the specific risk factors that matter presents. The description of the work and the value of the transaction is something that we often notice missing on the risk assessments of the files we review. So aside from the fact that it is a requirement under Regulation 2813A of the money laundering regulations, noting this information will be a useful reference point, again, as the matter progresses. You'll be able to refer to this information if the instructions change during the life of the matter, or if things are not noted down at the start, it's unlikely you would remember the conversation with your clients a few weeks or months ago. It would be easier if you can refer to something documented if you start having concerns or the instructions change. So the form contains some questions, as you see, to prompt when assessing the risks associated with the matter in question. So just wanted to point out that these are not intended to be exhaustive, and you should be mindful of other risks that might be applicable to the specific transaction that you're assessing. So there are two things I wanted to draw your attention to in this section, and the first is in relation to the source of funds box, where source of funds checks have been completed. It's important to document the checks that were conducted. So when was it done, how was it done, etc. Did it raise any concerns, or did it confirm what you were informed by the client? If you do not consider source of funds checks to be necessary, it is also equally important to document your considerations before you've arrived at this conclusion. So this is an area we often provide feedback to firms on when we review files as part of our proactive work. Another key question to highlight here is the matter transactional question. This question is asking if money or assets will be exchanged or transferred from one party to another. It's important to note that source of funds checks may still be necessary even if money is not going through your client account. So for example, in a circumstance where the matter you're instructed on involves arranging for the movement of funds or assets from party A to party B. So the next slide is on enhanced due diligence, which I'm just going to touch on quickly before I pass you over to Declan. Enhanced due diligence is required where there is a higher risk of money laundering. And we have used the risk factors set out in Regulation 33 of the money laundering regulations as the prompts to consider whether your matter requires enhanced due diligence or not. However, please note that these are not intended to be exhaustive, and you should consider if there are other risks your client or matter presents. Over to you, Declan.
Thanks, Michelle. So sections 3C and 4 are perhaps the most important part of your risk assessment, as these outline the risk level of both the client and the matter, as well as the level of client due diligence that you plan to apply, i.e. simplified, standard or enhanced. Now, one of the most common feedback areas we provide to firms when reviewing files on site is that the person who's carried out the risk assessment has failed to record their rationale around how and why they've arrived at the overall risk rating. As mentioned earlier, the purpose of your client and matter risk assessments are to show that you've considered all the risks and that you've taken the necessary actions to mitigate them. And the idea is that anyone else who's working on the file can have a read of the risk assessment so that they're aware of any risks which are present and what they need to look out for. Now, one of the main questions that we get asked by firms is how much information do they need to record under the rationale? And there's no real definitive answer to this. You record what you feel is necessary. The expectation is not that you write reams and reams of information, but instead that you detail any potential risk areas and what you've done to mitigate them. So, for example, in our example here, the person who's completed the form has drafted a few lines around potential red flags and what they have done or what they plan to do to mitigate the risks. They've also explained how they've arrived at the overall risk rating and marked what level of due diligence is required. Now over to Michelle to talk about ongoing monitoring.
Thanks, Declan. Okay, so section 5 of the template looks at ongoing monitoring, which is an essential part of risk management because any communication could bring with it a change in the risk profile of the matter, the client risk, or both. This is why risk assessments should be reevaluated at appropriate intervals. This will alert you to update the risk profile of the client, which may change over time. So for example, where there's a change in beneficial ownership, if you have a corporate client, a change in the nature of the client's business, or a change of address, etc. So you should review the risk assessment if important new facts or at key stages in the business relationship, and you should be looking out for new instructions that do not fit in with the profile of the client or are not consistent with the previous work you've undertaken for the client in the past. So it's important to record details of how you've monitored the identified risks since the form was initially completed, any changes you discovered since the form was completed, any changes to the risk level for the client and the matter, and how the client and the matter will be monitored on an ongoing basis if necessary. The form should be signed and dated by the person reviewing the risk assessment. This is actually something that we sometimes see missing on risk assessments when we review them. And finally, I'd like to emphasise that the risk assessment should be reviewed as many times as is necessary for the level of risk applicable to the client and or the matter. And I'll pass you over to Declan now for some key takeaways.
Thanks, Michelle. So before we move into the Q&A part of today's session, we've just got some key takeaways up here. So the first one is that for matters which are in scope of the money laundering regulations, a risk assessment should be recorded at the beginning of every matter for every client. Now, some firms choose to do this for all clients and all matters, regardless of whether the work is in scope of the regulations or not. If you do choose to only do risk assessments for clients and matters in scope, you'll need to ensure you have the appropriate controls in place to prevent passporting. So whereby a client initially instructs you on a matter which is initially out of scope, but then instructs you for an in-scope matter at a later date. Now, if matters for one particular client are highly repetitive in nature, where the risks remain consistent, you may choose to do an overarching matter risk assessment. You must, however, ensure your fee earners are closely monitoring these matters for any changes which may increase the risks. The next 2 points that we have up there are linked. So you must ensure your client and matter risk assessments are written down or documented somewhere. And this is for a couple of reasons. So number one, and perhaps the most important, being that other people in the firm who are working with a particular client or on a particular matter have access to it, so that they're aware of the risks that they need to look out for. This will also help them help your fee earners comply with their ongoing monitoring obligations under Regulation 28, as Michelle has just touched upon. So, for example, if the funding source for a transaction changes part of the way through the retainer, or if there's a change in the ownership or control structure of a corporate entity, examples like this may require you to adjust the risk rating and may require you to gather further due diligence. And by having your client and matter risk assessments written down, it helps evidence that you've considered the risks, which may protect your firm if we, at the SRA, or if law enforcement ask questions over a particular client or a particular matter in the future. So there'll now be an opportunity for us to answer any questions that you may have on client and matter risk assessments. So thank you to those of you who have submitted your questions so far. Mandy, can we have the first question, please?
Yeah, thanks, Bo. So coming to you first, Michelle. Do we have to complete risk assessments for every matter, even where we do the same type of work for a client?
Okay, matter risk assessments should be completed on each new matter where the risks are not repetitive. So there will be occasions where you do work for a client where you do repetitive work and you might feel that actually the risks are repetitive. So it might be acceptable in those circumstances to record an overarching matter risk assessment, which outlines the risks that matter presents and how the firm will mitigate them. But what I'd say is what we would expect to see in those circumstances is that at the start of each new matter, the firm reviews the risk assessment, the matter risk assessment, to check that their understanding of the matter, their understanding of the funding, understanding of the parties involved remain consistent. So if you have checked those and it's changed, obviously please do record those. If you check them and they haven't changed, it's actually just as important to record that there were no changes. Essentially, you should make sure you're documenting your rationale and the reasons you've taken that decision. To actually just have one matter risk assessment as opposed to doing it for each matter. And this will help fee earners working on a file understand the reason why the firm has decided to do that. And it would also help us when we come out to look at files, we would be expecting to see that information on the file.
Right, thanks, Michelle. Declan, one for you. On occasions, there may be anywhere up to 40 associates working on one particular matter. This can make reviewing the client and matter risk assessment difficult. Do all of the associates have to review the client and matter risk assessment, or can this just be shared with the lead partner?
So this is a question that we're quite often asked by sort of larger firms whilst we're on site. The short answer is no. The matter risk assessment does not need to be reviewed by everyone, every one of the associates. There are, however, a couple of caveats to this, and this should be taken on assessed on a case-by-case basis. The first is that the client and matter risk assessment should be saved in a central place where everyone who's working with the client or on the matter can access it if they need to, as we just covered off. The second is that if there are any high risk flags present, which fee earners do need to be made aware of. So, for example, if the client was a PEP or if they're in a high risk jurisdiction or anything like that, this should be shared with people who are working on the matter so that they're aware of what they need to look out for. Now, this could be done by if there's any sort of lead partners or if there's someone that has overall responsibility for the matter. Alternatively, you could add, I don't know, an alert or something to your case management system if the system allows you to do that. You should also ensure that, I guess, anyone that's sort of involved in the potentially high risk stages of the matter. So, for example, if there's any fee earners who are responsible for executing transactions, that they're made aware of the risks, so that they're aware of what they need to look out for.
Great, thanks, Declan. Michelle, coming to you with the next one. We don't use a template to risk assess matters at our firm. You recently published a template. Does that mean the SRA wants firms to assess risk using templates?
Okay, so the money laundering regulations do not specify how risk is to be assessed. So the short answer is no, we don't expect firms to use our template or any template for that matter, so long as the risk assessment or the risk presented in the client or in relation to the client or the matter is documented in some way. So we see that firms risk assess their clients and matters in several ways, from the inspections and from the desk-based review work that we do. So we're aware that most firms do use templates. So to be absolutely clear, we don't have an issue with that, provided that it's tailored to the risks that the firm faces. So we also see that some firms use like a systems-led risk assessment where it's inbuilt into their case management system. Others simply might just record an attendance note, setting out their considerations and actions that they've taken to mitigate any risks. Like I said, the important thing for us is that the systems or processes that you choose to use is in line with Regulation 2812 and 13. So, for example, if you do use a system on your case management system, as you can't just tick there was no money laundering risk, that wouldn't be sufficient. So the short answer was no.
Great, thanks, Michelle. Another one for you, Declan. Risk assessments within our firm are carried out by the client onboarding team and are sent to the fee earner who is responsible for the file. Is this process acceptable?
So this is the approach that we quite often see firms taking. And while there's no harm in taking this approach at all, you must ensure that the person who's responsible for the matter has reviewed the risk assessment so that they're aware of what they need to look out for, given that they're sort of closer to the detail. What you want to try and avoid is that risk assessments are just being filed away by fee earners or by the fee earner without looking at them, so that they're unaware of the risks. So we've seen different approaches taken by firms to ensure that fee earners have reviewed risk assessments. Some firms require fee earners to feed into the risk assessment process. Some firms require their fee earners to sign a confirmation that they've read the document. I guess how you do it is down to you and what works best for your firm. Ultimately, what I would say is, it's your fee earner who could end up in trouble should anything happen on a file. So it's in their interest to review risk assessments so they're aware of what they need to look out for.
Great, thanks, Declan. Michelle, question in from Amanda Norton. Do you require separate client and matter risk assessments, or can they be combined per matter?
Okay, so the regulations again don't specify a format, as long it just says you have to do it. So it's entirely up to you how you choose to do it. You can combine it, or you can review client risk separately and matter risk separately. And we have seen where firms are doing both, taking both approaches. So provided that it's being done, that's the key point. That's the important thing.
Great, thanks, Michelle. Declan, another one for you. Question in from Taranjeet Salhal. As source of funds checks can take time to complete, waiting for statements, documents, specific replies. Can a conveyancing matter proceed with a risk assessment partially completed to then be finalised when all the funding information is received?
Yeah, I think it can, as we've kind of demonstrated today. What I would suggest with these types of matters are that you carry out your initial risk assessment to see if there are any red flags present at the outset that need to be mitigated. And then you can carry out your source of funds, and if required, your source of wealth checks at a later date. So again, going back to our example, you'll recall that there was an initial assessment as to why we were being instructed from someone outside the local area and what steps that we plan to take to mitigate not meeting them face to face. In terms of the source of funds part, what I would just say quickly is, you don't want to start your source of funds checks too late in the transaction, right before completion, as that could potentially delay the matter if you have to ask for additional documents. The sooner you get your checks done, the better, but obviously you want to keep an eye out for any changes.
Oh, sorry, if I could just add to what Declan's just said. So if you decide you want to conduct source of funds checks, well, if you check a bit late in the day, so you might have already committed your client to the transaction. At that point, when you then get information, you might form a suspicion, which you would then be required to submit a suspicious activity report to the NCA, which obviously it's going to be quite an uncomfortable situation because you can't tell your client that you formed a suspicion. So just to echo what Declan said, the earlier you get it done, the better.
Great, thanks, Michelle. Question from Lindsay Newman. I'll bring that to you, Michelle. We are an employment law firm. We don't have a client account and don't therefore hold client money. I'm assuming that our transactions are therefore low risk on the whole.
Okay, so employment law usually doesn't fall in scope of the money laundering regulations. However, it depends on if you're doing, for example, if there's tax elements to that. So some part of it might be in scope. So it would really depend on exactly what type of work you're doing. The other thing I wanted to say was in relation to the fact that you don't have a client account. So again, just wanted to emphasize that just because you don't have a client account or that money's not passing through your client account does not mean that your work is necessarily going to be lower risk. So I think we probably need to look at this in a bit more detail to be able to say what's low risk or not. The spirit of the regulations is to take a risk-based approach. So if you consider the facts and there are no red flags, there are no high risk situations, circumstances, considerations, then you could say, you know, you might be justified in saying it's lower risk.
Great, thanks, Michelle. Coming to you then, Declan. Question from Gerdy Vator. If the client risk assessment is marked high risk, does that mean automatically that the matter risk assessment should also be marked high risk? Or is it okay that the client is high risk and EDD has been completed, but the advice on the matter is considered low risk?
Yeah, I think that's fair. I think, you know, you can have high risk clients getting low risk advice and vice versa. Really, you know, you can have sort of, you know, low risk matters that might involve high risk clients. I think the key thing is that you're assessing both really for each of the risks which are present. So to kind of summarize the question, if I've understood it right, yes, you potentially may have a high risk client where you're giving low risk advice. That's absolutely fine.
Great, thanks, Declan. We've had a comment in as well on the template that we have issued on that it doesn't look to cover entities. So the section is there, it's not in section 1, it asks you to go to section 2E of the template. So if you look at section 2E, there's a section there to cover off entities and the details that you've got for the shareholders and the ultimate beneficial owners in that area. So another question we've had in, Declan, I'll come to you with this one. Do we have to carry out risk assessments on personal injury cases and employment law where we are not receiving any money from the client?
So I think Michelle's just touched upon this, hasn't she, about the receiving money from the client or not doesn't necessarily mean, you know, you do still have to look out for the risk. I think the key thing here for personal injury and employment law, again, is considering whether or not the matter is in scope of the regulations or not. I think, you know, that will be my first port of call, is to assess actually is this matter within scope of the money laundering regulations. So what I would suggest is, you know, have a look at regulations 11 and regulations 12. Regulation 12 applied to obviously the legal sector. Regulation 11 captures tax advice, which may bring the work into scope. We have produced guidance on the on tax work a couple of years ago. We put some guidance out whether the work is in scope or not. So I'd suggest that you do read that. But I think, yeah, I think the first thing is you need to consider or not whether the work is in scope of the regulations.
Great, thanks both. We've had quite a few questions in today, so apologies for those that we haven't had time to answer. We will look through those and look to cover them up in future webinars or Q&A if we can. On that note, we really do want to hear your feedback on the webinar today. So if you found it useful or have any comments on the content, please do fill our evaluation form in. And you can find the evaluation link at the bottom of the video, and any delegates that have registered to this webinar will also receive a link by email by the end of today. It's a short form and shouldn't take longer than 2 minutes to complete, but it would really help us to improve. So please do complete that for us. Thank you for your time today, and goodbye.